The book's title is International Commercial Arbitration. The subtitle is An Asia-Pacific Perspective, and the authors are Simon Greenberg, Christopher Key, and J. Romesh Weeramantry. The book's published by Cambridge University Press and is a reprint of 2012. The chapter 1 of the book is to offer an introduction and definition to international arbitration. It presents a history of its place, i.e., Asia Pacific. The initial sections of this segment deal with the general topic of the advent of the modern international law. The third section of the chapter represents an account of the development of a framework for international arbitration. This section denotes areas such as the 1958 New York Convention, 1965 ICSID Convention, and 1985 Ancestral Model Law on International Commercial Arbitration. The third section of the chapter puts forward characteristics of arbitration as envisaged by authors. For example, distinction between arbitration and litigation, or distinction between international arbitration and domestic arbitration. Key features of arbitration such as arbitration agreement, arbitrators, party autonomy are also expounded in this section. The chapter also includes a section examining summarily international arbitration in the Asia Pacific. This encompasses the growth and culture of arbitration there. Chapter 2 delves into the area of law that governs the arbitration and rule of the seat. Initially, there is a discussion of terminology on offer, for example, distinction between the seat of arbitration and venue of hearings. Allusion in detail is made to lex arbitri, arbitral procedural law, and arbitration rules. The following two sections of the chapter are allocated to mulling over diverging views on link between arbitration proceedings and seat of arbitration, as well as the selection of the seat of arbitration. The last section of the chapter is on model law as lex arbitri. Chapter 3 considers applicable substantive law. The areas dealt with in the chapter include categories of conflict of law issues in international arbitration, determining the law applicable to the substance of the dispute, limitations on choice of law, trade usages, non-national rules of law, and the lex mercatoria, deciding cases without law as well. Chapter 4 serves the arbitration agreement. The preliminary section expounds the nature and types of arbitration agreement. Doctrine of separability comes next in the chapter, where issues such as independent determination of the validity of arbitration law from national laws are explored. Other areas discussed in the chapter are identifying the parties to an arbitration agreement, defined legal relationship, consolidation and joinder, and third-party notices, as well as enforcement of arbitration agreements and arbitrability, draft arbitration agreements next to the rest of them. Chapter 5 revolves around arbitral jurisdiction. It covers issues such as arbitral tribunals' determination of jurisdiction as well as effects of jurisdictional decisions. Chapter 5 is an investigation of the arbitral tribunal. It covers the very significant issue of the constitution of tribunal as well as the process of choosing an arbitrator. Challenges faced by arbitrators are also of concern in this chapter. Next, to the way they resign their mission and how they can be replaced. Chapter 7 offers a detailed perspective on procedure and evidence. The principal areas of investigation here are first the party autonomy, procedural law, core procedural rights and duties, balancing common law and civil law procedure, the fundamental issue of arbitral proceeding at the end of it. Secondly, the chapter devotes a large space to areas of evidence, hearings, interim measures, security for costs and privacy and confidentiality. Chapter 8 deals with the concept of award and its content and form. The chapter offers details on content, form and effect of arbitral awards next to definition and types of arbitral awards. Chapter 9 proceeds with the topic of award, yet through dealing with challenges and enforcement areas. Chapter 10 is an exposition of investment treaty arbitration. Issues of concern here are international investment law, the International Center for Settlement of International Disputes, assessment of ICSID Convention, substantive rights and protections under investment treaties, remedies, annulment of ICSID awards, and enforcement of ICSID awards. The book is recommended and a good read for those who want to know about international arbitration process and procedures from a regional point of view.